Hi, good afternoon, everyone. It's indeed on behalf of the Dean of the Faculty of Law, Professor Avinash Governji. It is my pleasure then to act as the moderator of this public lecture by our newly appointed adjunct professor, Professor Henry Lerm. Just to introduce myself to you, I'm Dion Erasmus, Professor of Law and the head of the Department of Criminal and Procedural Law. It is also in that department that Professor Lerm has been appointed as an adjunct professor. I'm just shortly going to share with you just a few facts about Professor Lerm, and then I'm going straight over to him, where he will then start with his lecture. You will note that there is a Q&A column in the Teams screen. So during the course of the lecture, if you have any questions, you can just type it in and we will be able to see it. Permitting time, we will try and answer as many of the questions as possible. Professor Lerm has a legal career stretching for over 25 years. He's also presently serving in our law clinic, I think more as a community service than anything else. He obtained the degrees B.Proc, LLB and LLM, and in 2009 he was awarded a LLD degree. It's rare that we find practitioners actually obtaining their doctoral degrees, because at the time he was the head of the Legal Aid Justice Center in Uitenhage. He was also involved in, to an extent. He was a member, and he's still a member of NADAL. He's also the deputy chairperson of the SA Medico Legal Association of South Africa and the chairperson of the Eastern Cape chapter. He has published numerous papers and conferences, and he retired, as I said, as the head of the Legal Aid Center, Justice Center in Uitenhage. He also argued quite a couple of cases in the High Court, some of which were reported. And throughout his career, he participated in numerous community engagement projects, and hence also as an adjunct professor, he once again offers his services and vast expertise to our staff and students. Henry, I'm giving over to you now to start your public lecture.
Thank you, Professor Erasmus. The Honourable Dean of the Faculty of Law, Professor Governji, the head of the Department of Criminal and Procedural Law, Professor Erasmus, fellow colleagues, ladies and gentlemen, good afternoon to you all. Thank you for attending and sharing with me my first public lecture after being appointed as an adjunct professor by my alma mater, the Nelson Mandela University. When I commenced reading my B.Proc degree in 1981, I would not in my wildest dreams have treasured the idea that one day I would be given this honor. It is with great humility then that I expressed my deepest appreciation to those who made it possible. Since reading stories during my childhood about professors, I have always respected and admired those learned people. What I did not know then, nor did I know at the time when I was reading law, is what influence professors bring to bear on law in general, their students, and how they inspire them to achieve. When attending lectures, I was often transfixed at the words they uttered about the law, the different poses they struck in the lecture rooms, some pacing up and down like ringmasters, often and others writing feverishly on a green board as they brought the law to life. And so, unbeknown to them, professors leave an indelible mark with each of us having our own story to tell. allow me to share with you just one of many stories that I treasure. This scene played off in a legal jurisprudence lecture when the legendary Professor Frick van Zyl acted as the ringmaster. On this day, the professor was in his element, trying very hard to bring alive Professor Herman Dooyeweer's theory of modalities and how they govern our lives. I was doing my articles of clerkship at the time and a touch older than my fellow students. So I dared to enter the lion's den when I debated the issue of Professor Dooyeweer's theories with Professor van Zyl. And the modalities which the professor espoused. As a matter of interest, the professor taught at the Amsterdam University in the Netherlands from 1926 to 1965. And what I try to convey to Professor van Zyl is some of those modalities are outdated. And obviously, the professor was taken aback, and I remember so well I was put in my place very quickly when he suggested, at this university we do not groom advocates for the profession, we train law mechanics to go into the field. What followed, of course, was I kept very quiet throughout that particular lecture. Now let's proceed then to the main purpose of the day, and that is why we are here. You are aware of the theme of my lecture today. It concerns interdisciplinary learning for medical and law students at university, a path to what I perceive to be good practice. You'll see, as far as the introduction is concerned, what I will do first of all is what made me choose the theme to this particular lecture, and I'll spend a bit of time on that. I believe that a need has arisen in South Africa that we need to integrate learning at university where we teach to medical students the law, and likewise, insofar as law students are concerned, teach them something about medicine as well. And the reason for that is that there has been a rise in medical malpractice and or medical negligence cases in South Africa, and that gave rise to a medical legal industry and a emergence of a new blend of professionals consisting of healthcare practitioners and legal practitioners who pool their skills and knowledge in becoming medical legal practitioners. And I must add that I'm very fortunate to be a member of the South African Medical Legal Association, where we do a lot of training for medical legal practitioners. But I believe that it is important to start at the cradle of educating law students and medical students to integrate at university level already, to make them better practitioners, and then once they want to enter into a medical legal practice and the field of medical legal practice, that they will be better equipped one day to become medical legal practitioners. You'll see from the next slide that to belong to this medical legal field requires particular skills and knowledge in both disciplines, law as well as medicine. and practitioners in both professions encounter the interface of law, medicine, and the Constitution in their practices. In my experience and having taught many courses through the South African Medical Legal Association, I have encountered how little those who come into medical fields know about the law, and likewise how little lawyers know about medicine when they start practicing. And often candidate attorneys are confronted at a very early stage in their careers as candidate attorneys that they have to engage with experts as they are assigned certain cases by their principals involving medical negligence matters. And then I make the point that in modern day practice, both medical and legal practitioners are often subjected to a multitude of laws, both legislation and the regulations, as well as codes of ethics that sometimes overlap in their practices. And because lawyers and healthcare practitioners have for centuries only been trained in their own discipline, they acquired knowledge and experience only in their disciplines, and when they come into contact with medical negligence cases or medical malpractice cases, they learn by way of default, by observing other expert witnesses or other lawyers, how they handle the cases that they are involved in. So I emphasize that the experience which they gain is merely by way of default. And I believe that they would be far better equipped one day when they engage in medical negligence matters if they could be taught at the cradle of learning, and that is at a university. And particularly in or at universities where you have a medical school as well as a law faculty. Now, at the Nelson Mandela University, we are very fortunate that in 2021, a medical school will open here in Port Elizabeth, and then we would have both a medical school as well as a law faculty. And I'll make the point as well that integrated learning has become a must in the 21st century. Now, the questions which are posed here will give you an indication why it is important that there has to be a paradigm shift in the way of teaching at the university, particularly where you have the benefit of a medical school as well as a law faculty. So I pose the following questions. What is the meaning of interdisciplinary teaching and learning? And I'll provide an answer for that in due course. What is the current method of teaching medical and law students? To that, I'll also provide answers. Has the current methodology of teaching served its time? I'll venture to suggest that yes, to a certain extent, but with qualification. And what alternatives, if any, are available? And I would then suggest what could be done to produce better qualified lawyers as well as doctors who enter the field of medicine as well as law. And then I plead for an integrated model of interdisciplinary learning. And then I'll leave you with a conclusion. Now, as far as the meaning of interdisciplinary teaching and learning is concerned, and this obviously is aimed in relation to law and medicine. You may have interdisciplinary teaching and learning in other fields, other disciplines as well, but we concentrate only on law and medicine. The definition I found, which I liked, is that it is a method used to teach across different disciplines, creating opportunities for students to find a path to good practice into their careers as lawyers and healthcare practitioners or medical legal practitioners. Now, the term healthcare practitioners has a very wide import. That could include your doctors, specialists. It may even include nurses for that particular matter, as well as any allied healthcare practitioners or medico-legal practitioners. And we already touched on that in the first slide, that it is a new discipline that has probably started developing in South Africa in the last 7 years or so. Now, what are the benefits of the methods to learners? That is integrated learning. I suggest that they use their shared knowledge very creatively. It prepares students for lifelong learning and promotes intellectual rigor and a holistic approach to complex issues. When one encounters these complex issues in practice, let's say, for example, a lawyer who encounters a medical negligence matter, you have to know something about the anatomy. You have to know something about the procedure and practices adopted by medical practitioners. You have to know something about ethics, informed consent, etc., etc. And what better way to empower those who are at university than also teach them other disciplines such as medicine for the lawyers, and likewise where you are being trained as medical healthcare practitioners. It's the start of your not career in practice, but at university when you are being taught there, to also get to grips with what are the practices that lawyers adopt, what procedures do they have, what are the ethics that govern the practice of law, etc. And what's important here is the collaboration of teamwork across disciplines. It's very, very important. Yeah, I believe that it opens up a front one day where you have better communication, more effective communication, less distrust between the two professions. And you can only achieve that by having a deeper understanding of each other's professional practices. Then there's also a spin-off or benefit for those who teach at the university. And what I am suggesting is that we get people involved from the professions, experts in the medical field to come and teach certain subjects at university level, where you have joint sessions involving law students as well as those that are being trained to follow a career in medicine one day. And that in itself, I make the point, is very enriching for those who come to the universities from outside to teach their skills and experience to the upcoming young professionals. I make the point as well that the introduction of the interrelationship of law and medicine is not new. It has developed over a number of years, more recently more in the United States of America than elsewhere. I know of a fellow director at the South African Medical Legal Association, Dr. Anton van der Boot, who is an orthopedic surgeon, but when he read medicine at Leiden University in the Netherlands in 1973, he conceived the idea that perhaps they should have integrated sessions of learning at the university. He later immigrated to South Africa and pursued that very concept that he conceived at the university level, shared that with fellow medical people as well as lawyers. And so the movement of the South African Medical Legal Association was started in South Africa. So it is not a new concept. Yes, the Americans have been forerunners, which I will point out to you that at certain universities in the United States of America, they have introduced the centers at their universities to train jointly the medical students as well as lawyers. The second bullet, insofar as the interrelationship between medical practitioners and legal practitioners are concerned, can be seen against the backdrop of the medical legal practice. We at the South African Medical Legal Association has defined medical legal practice as conduct involving or relating to all areas where healthcare and law interact. You'll see then revisiting the United States of America and what efforts have been put in place there to integrate law students and medical students at university level. This emerged at the Boston University under their Law School Center and the Health Science in 1976. And the whole idea was to develop at an early stage the skills and knowledge about both disciplines for those who will pursue their careers in law and medicine. Now, what is the current method of teaching aspirant healthcare and legal practitioners at university? I believe that it has been an orthodox and conventional method of teaching which has been there for a number of centuries. You have two distinct conventional curricula offered to those wanting to become doctors and those seeking to become lawyers. Those who study medicine will follow a clinical skills course in their initial stages of learning, followed by a more practical training in medical units, as well as district hospitals and the community health centers. The law students follow a conventional curriculum as well, where standard subjects like jurisprudence, criminal law and procedure, contract law and the like are being taught, but no contact is encouraged between medical students as well as law students, like I said, where a university has the benefit of having a law school or law faculty as well as a medical school. It's only in the fourth year that your law students are exposed to the law clinics, street law programs, where they are exposed to a shade of practice, and so they are exposed to very little knowledge about other disciplines. Now, as far as the law clinic and law clinic is concerned, I believe in future they have a greater role to play where you have a medical school as well as your law faculty, where they see clients and may refer the clients, then clients who may have been injured as a result of medical negligence cases need further attention also could be then referred to the medical school for the necessary diagnosis, etc., and then further action thereafter. So I believe that in future, law clinics could play a very vital role in a go-between the law students who work at the law clinics, as well as then the medical school where your aspirant doctors are being trained. So I'll also make the point that at universities where they host both medical and law faculties, very little, if any, contact is being made between the two disciplines. I'm aware in South Africa that there are a number of universities where you have medical schools as well as law faculties. There may be some contact, but as far as my knowledge goes, it is very sparse, the contact between the two disciplines. And then the effect of this stereotype method of teaching is said to have resulted in that lawyers, healthcare practitioners are very ill-equipped when they enter practice, and they, for the first time, deal with issues where the law and medicine interface. And then two gaps have been identified. The present medical training program does not include a blend of legal framework, making them aware of legislation and other rules governing their professional careers. And the same applies then to candidate attorneys entering the legal profession as during their internship as candidate attorneys. They may be asked, and I don't want to repeat myself, but I think I used the example early on, that their principals may ask them to attend to certain cases which involve contact with expert witnesses or so, and yet they know so little about the practices and procedures encountered by medical people in their professions. And it's very difficult then to come to terms with concepts such as negligence, causation, as well as the aspect of quantum. These are alien concepts, and I believe that requires a certain course in human anatomy, and such courses cannot be learned overnight. And once again, I believe the cradle of learning is at university, and there you could, and I would recommend that a course of human anatomy is offered to your law students. And what I encourage further is, besides a course being offered to law students, there are many other, as we'll see later on, courses that should be integrated, should become integrated learning, where both counterparts enjoy the benefit of the teachings in joint sessions at the university. Has the present orthodox methodology of teaching law students and medical students served its time? And I make the point here that I think it would be unwise to just abandon a curriculum that has been put in place for law students on the one hand, as well as medical students on the other, to abandon that altogether. I don't believe it is healthy. It would lead to a lot of instability also. These are still two different disciplines or professions. What I encourage is that there has to be some integrated learning where certain knowledge could be shared in certain subjects, which I will take you through when we get to the recommendations which I have formulated later. And I make the point here that there has to be interdisciplinary training methods to be adopted in their respective curricula, and the old established conventional or orthodox way of teaching certain law subjects or clinical subjects in medicine should be modified to accommodate then your collaborative teaching and learning. Two universities in the United States of America, namely the University of Baltimore as well as the Johns Hopkins University, have introduced integrative models at their universities, and they have come out strongly in favor of this method of teaching and education. And you'll see from this slide that studies at both the universities reveal then that there are some benefits that may come from the modified way of integrated teaching, and they could include then your joint training in complex concepts and theories, especially where interrelated skills transfer can take place, offer the following benefits to the students. They become critical thinkers and better problem solvers. They have a better foundation that is laid where you have integrated learning, and they can learn from each other the theories and so on that their counterparts encounter in their own professions. Knowledge and shared experience gained in that way encourage effective communication carried forth into their careers. And I believe that especially those who find themselves going into the field of medical legal practice, they need that shared experience. They need to gain more experience in the opposing disciplines, if I can put it that way. Perhaps opposing is not a correct word, because that signifies that they should remain opposite. More a matter of they should have a greater understanding of each other's disciplines or practices. And then the improved learning complements then the primary skills needed to succeed in their own particular practices. What I've encountered in the time that I have been teaching, both lawyers as well as medical people, medical practitioners or healthcare practitioners, is this: they know so little about each other's fields, and they would be richer if they had or if they do know more about each other's fields. For example, your healthcare practitioners are governed by laws, governed by the Constitution, yet I have encountered situations where unfortunately what's shown up is the ignorance about the laws and the Constitution. And I think that the same can be said about lawyers who venture into doing medical legal work or take on medical negligence cases or medical malpractice cases, they know nothing about the anatomy, how the body works. Medicine is not an exact science. Anything can happen. It's not necessarily so that if someone is injured or so that one can ascribe that to negligence. These are the aspects that young professionals should be taught at a university level. And it brings an improved readiness for professional practice. Also, I believe that to have these joint sessions would serve as a transformative vehicle by improving skills, values, and practical habits that stay with the young professionals throughout their careers. And it empowers the young professionals in learning about ethical and fundamental practices of other professionals. Working collaboratively then influence the way in which the professional students from both disciplines work together as future professionals. We are spending billions of rands at the moment on litigation in South Africa. Sometimes these cases emanate from a lack of ignorance. And I believe that, and also as a result of a lack of communication and distrust. If there is trust, it improves communication, and for that reason, I believe that matters could be solved more readily than having to expend billions of rands on fighting each other in a court situation, whereas they could talk to each other and finding common grounds to resolve issues. And this is where I believe that they should also be trained in what is mediation and the positive side of mediation insofar as better future relationships are concerned, it's less costly, etc. And then it teaches them to foster respect and appreciation amongst the two disciplines, which can be carried into their practices. That's precisely the point I want to make. And that is they have respect for each other. By having respect for each other, one can resolve those disputes far more easily. And then it develops the educational mission of medical legal practitioners from their formative years, the cradle of education, as I call it. And such outcomes, as described here and before, would greatly influence the healthcare system as a whole. Those that are aware, we are going through a crisis in South Africa insofar as our healthcare system is concerned. And I believe that one way of assisting with that is through an integrative approach already at university level to prepare future professionals for entering their respective professions in a better position where they have the necessary skills and experience which they acquire at university level already. Now, insofar as an integrated course is concerned, I've thought about it, and also I'm indebted to people that I'd spoken to, especially Dr. van der Boot, engaged with him quite recently and discussed with him what type of integration can we bring about at university level in future. And he was quite prepared to share with me his ideas, which obviously has stayed with him since 1973. I'm not going to prescribe a curriculum at this stage. I believe it is up to the Department of Medicine in collaboration with the law faculty to develop an academic program where you have combined courses between the two disciplines. I'll just share with you a couple of ideas. I believe it is imperative in the first year that the young professionals should be influenced by professional ethics, and that should be taught at first year level already, and it should be an integrated course. Both disciplines should attend this course. I also believe that there is a need for legislative enactments to regulate medical treatment and medical care to healthcare users against the backdrop of Chapter 2 of the Constitution at perhaps second year level. What is a must for law students is a course in human anatomy and the functions of the main organs of the human body, and that could also be offered at the second year level. Medical students should be schooled in basic subjects of law, such as criminal law and procedure, law of evidence, forensic evidence, medical law, and then the law of dealing. If one does not introduce these subjects at university level, they unfortunately face the hardship when they enter their careers and they are being subpoenaed to come to court to come and give evidence or so. They don't know how the legal system works, and it just brings on agony, anxiety, as they await the certain day when they have to appear as a witness in court. Whereas if one can teach that on a foundational level at university, that just prepares them for their careers. And should there be a need for them to be exposed to the legal system. Then, as far as a course is concerned, both, I believe, for medical students and for law students, there should be a course designed in the science of human behavior in relation to legal and social problems, as well as the need for psychiatry and clinical psychology in the field of criminal mental health, as well as forensics. Year 2, I make the point that there should be interdisciplinary learning should be introduced. Then in the third year, both medical and law students should be introduced to practical procedural subjects, including a foundational module in litigation and alternative dispute processes. Once again, this could be an elementary course that is being taught there with foundational principles, but I believe that it can only benefit them before they enter their careers in practice. I believe that an integrated course could also touch on aspects such as pre-trial practices, including joint meetings, joint minutes between experts, and a preparation for trial. How do you prepare for trial? Also then what follows is trial practices, including giving evidence and being subjected to cross-examination also. If that is taught at the cradle of learning at university level, I believe that they would know something about that, and when they are exposed to cross-examination, it is and will always be remain daunting, but it would be less alien to them because at least they know the basics, what it is, what you go through, what to anticipate, etc., etc. Ethics governing trial lawyers and expert witnesses. I believe it's also very important that that be taught at university. Ethics permit us, notwithstanding what profession you belong to, it is such an important aspect, and yet we don't seem to emphasize that particular subject at university level. Then the interdisciplinary postgraduate courses could also be offered. Here it is suggested that a master's degree course in advanced medical law and ethics studies be designed and offered to those who wish to pursue higher learning. A course for final year registrars on the verge of specialization in their field of expertise as medical specialists should act as a precursor to their recognition as specialists. In other words, before they become specialists, there has to be a certain course offered to the aspiring specialists, medical specialists. And this course material could include medical malpractice and defenses available to doctors or medical people. Informed consent is very important, and then any other related areas of practice. And then in conclusion, I make the following point, that I believe that the orthodox method of teaching young professionals in law and medicine is in need of change. A new educational model founded on the principle of interdisciplinary training, where law and medicine interface, is strongly recommended. Teaching law and medicine beyond the basic sciences in a collaborative and holistic manner, where possible, not only prepare them more fully for practice in their careers, but it would also give them an opportunity to pursue a career in medico-legal practice if they so wish. And then finally, I would like to leave you with the following thought. This idea may today still be nestled in the womb, but hopefully in time it will be released and become a reality, and I sincerely hope I could be part of that. Thank you very much. Dion?
You're muted.
Thank you.
Okay, sorry, I was mute. Thomas warned us earlier that we must be careful about that. Henry, thanks for a very interesting lecture. You will, of course, know that all law faculties recently went through a process of restructuring their curriculum. I'm also supervising one of my colleagues who also feel that we should try and get students more ready for practice, generally when they enter the legal practice. Those of you who have questions, you just need to type it in the live event Q&A, and then I will send them through to Henry. Professor Esmeralda Riggs just made a comment, and she said that not only medical students, but all health science students should really also be part of this integrated training. Henry, your thoughts on that?
You're muted, Henry.
Yeah, that's a cardinal sin I committed. You know, you must always look at that button and see if you muted. Yeah, sorry about that. Yes, I fully endorse the comment. I made the point early on that as far as healthcare practitioners are concerned, it's not only your actual doctors, specialists, it could include nurses, and it could stretch beyond that and include the other health sciences as well, psychologists, psychiatry, etc., etc. But thank you very much for that valuable contribution.
Thank you. Are there any other questions from any of the delegates attending? Henry, I was just also thinking of one aspect, having been involved in the whole recurriculation process. Sorry, I always battle with that one. You know, the academics would say, yes, it's a good idea, but where are we going to get time to fit that into the curriculum? So I was just wondering, and that is just an idea I'm playing with, would it be possible, maybe like in the 4th year, if students could get various, you know, options, if certain law students, for instance, would say, look, I would like to go into medical malpractice, others would say, no, I would like to go in commercial or whatever, that one could maybe in the 4th year, you know, specialize and then maybe bring in the type of integrated approach that you suggest. But as far as the medical students are concerned, I'm all the way with you. You know that they really need to be introduced to the legal concepts throughout their training. What is your view on that?
Yes, thank you, Leon. I have given that thought. And when I was pondering and in anticipation that this may very well become a question that may arise after the lecture, well, firstly, I will answer it as follows. I am aware of the time constraints. Yes, it is a reality at university. The plates are so full as it is for students, but generally speaking, I don't believe that time should pose any obstacle to further development. We must make time, but at the same time, one has to be realistic about it, and I believe it has to be an elective. And I agree fully with you. You can't expect every law student who some may want to go into aviation, some may want to go into the criminal courts, some may want to go into commercial fields, as you already alluded to. So therefore, why subject them to a course of this particular nature? You would then rather have those who want to and can foresee themselves going into personal injury law practice, or they would be dealing with medical negligence matters or so, specialize in that. They should be encouraged to pursue courses of this nature, but it doesn't stop one from introducing your elementary courses like ethics and so on a combined basis, as I suggested earlier.
Thank you. There's a question from Pumza, and who asks, will the NMU be looking at including medical law as an elective for final year students? I don't think you can answer that, but you've now just proven to us that you will be a very good person to present such a course. What are your thoughts on that?
Well, I'm here to serve. I don't know if I've answered it. I would.
Okay, thanks very much, Henry. Seeing that there are no, let me just finally check. It would seem that those are all the questions. Oh, there's another one from Anonymous. We need to change from medico legal to healthcare legal. It's a misnomer to only link it to medicine. What are your thoughts on that?
It is something that one can think about. I cannot give you a specific answer, but if it includes the other sciences as well, we may very well have to rethink the term medical legal practitioner to include perhaps the suggestion that is being made, healthcare legal practitioner. So I can assure you I have made a note of that, and perhaps what I will do is at a similar level, the South African Medical Legal Association, we could perhaps debate that and ventilate that issue at that level. But thank you for that suggestion.
Thanks, Henry. Okay, I would then just like to close this public lecture at this stage. Thank you for everyone who made time to attend this lecture. I'm sure you will agree with me, it's a very interesting lecture. It leaves a lot of food for thought. As I said, with university curriculums, law curriculums, we're in a continuous process of restructuring and also trying to meet the demands of practice. And as Henry has clearly indicated, medical legal practice is a multi-million business, not only in South Africa, but in a lot of countries. And I think the idea also that stood out is that although there's not agreement on this point, but some believe universities are there to teach students the law, the theory, but the other school of thought is that we should, at university, try and get the law students ready to enter practice, not to be attorneys or advocates at that stage, but at least to be able to apply basic principles and tasks when they enter practice. And I think Henry's whole view slots in with this. Henry, I think you will surely be contacted by some of our students, seeing that you are now an adjunct professor. I think a lot of the students also know you from the law clinic, where you actually are also involved at the moment. So yes, we're looking forward to more research and lectures being presented. Thank you everyone for attending and showing an interest in our faculty and our department. Thanks very much. Goodbye.
Thank you for the opportunity, Professor Erasmus. Thank you.